Dissolution of Muslim Marriage Act 1939 is applicable to all Muslims irrespective of the sect or school they may belong. Section 2 contains 8 fault grounds and Section 4 relates to apostasy. So, under this act, it is the Muslim wife, not the Muslim husband, who can suit for divorce. The wife may obtain a decree of divorce on any one of the grounds specified in the Act by filing a suit in the lowest civil court. Previously, under the Shariat Act 1937, it was laid down that such suits could be filed only in the district court. So, out of the 8 fault grounds of divorce, the first one is the whereabouts of the husband are not known for a period of 4 years. The wife is entitled to a decree of divorce, but such a decree will not take effect for a period of 6 months from the date of such decree, and if the husband appears either in person or through an agent within that period and satisfies the court that he is prepared to perform his conjugal duties, the court must set aside the decree. And the second ground, that is under the foreground, is failure to provide maintenance for a period of 2 years or more. So, the failure of the husband to provide maintenance to the wife for a period of 2 years or more, the wife is entitled to a decree of divorce. In the leading case, Manak versus Mulk Khan in 1941 and also in Satganj versus Rehmat in the same year in 1941, the Lahore and Sindh High Court expressed that the inability of the husband to maintain his wife or the failure of fulfilling the health or loss of work or on account of his poverty or imprisonment or any other cause whatsoever is no basis for refusing the wife's decree for divorce. So also in the leading case, Said Ahmed versus Taj Begum in 1958, the Mysore High Court observed that where the wife is living separate from her husband on account of his failure to pay her prompt dowry, and the husband does not provide her maintenance for a period of 2 years, the wife is entitled to a decree of divorce. Similarly, a wife is living separate from her husband and to whom maintenance has not been provided for a period of 2 years or more is entitled to divorce, as it was also decided in the leading case Kandaswamy versus Wachmul in 1963 by the Madras High Court. So also in Said Ahmad versus Sultan Begum in 1983, the Peshawar High Court rejected the plea of the husband on refusing to pay maintenance as the wife is rich. So these are the two main important grounds which falls under four grounds of divorce, and with the leading cases such as Manak versus Mulka, Satganj versus Rehmat 1951, Saeed Ahmed versus Taj Begum 1958, Kandaswamy versus Wachmul 1963, Saeed Ahmed versus Sultan Bibi 1983. So, in those leading cases, it was also being held that the husband, if he failed to provide maintenance for a period of 2 years or more, then the wife is entitled to file a suit for divorce. So, our next 6 fault grounds we will discuss in the upcoming video.